Okay, good evening, good afternoon, everyone, and welcome. Thank you for joining us today for an important discussion on the recent USCIS adjustment of status policy that has changes and what they could mean for current future green card applicants. Immigration policies continue to evolve, and even a small procedural change can have a significant impact on eligibility, documentation, filing process, etc. Our goal today is to help you understand these developments in a practical and accessible way so you can make informed as well as make a proper decision about your immigration journey. And as we all know, we have Nusrat. She's experienced immigration attorney with us. So she will definitely going to help us and understand what this policy actually mean and what are the steps that you all can take to make sure that you are proceeding in the right manner. Nusrat, over to you, and thank you so much for joining us today.
Hi, Swati. Thank you so much for having me. So, I think everyone's heard now about this proposed policy change. It sounds very sweeping and big and bombastic, and I think it's intended to be. So, this administration announced that they see adjustment of status as an extraordinary form of relief, and that it requires a high bar for a positive exercise of discretion before an adjustment of status application can be approved. Now, this policy was just announced a few days ago, and we're still figuring out what it means. There's a lot we don't know at this point, and we don't know how this is going to play out. What we know is that the administration is proposing that there be, that essentially adjustment of status be seen as a rare privilege rather than a routine application, and that they intend to apply this discretionary standard, which has already been made part of the policy manual, that explains certain elements will be weighed as either positive factors or negative factors in deciding whether an adjustment application will be approved. So the kinds of factors that they name include the type of status somebody was in at the time the application was filed, their connections to the community, positive contributions to the community they're in, whether they can contribute positively to the United States. Negative factors include, whether this person was not in a quote unquote correct status before applying for adjustment of status. So that means lapses in status or a status that's not dual intent. One that is not dual intent would be, for example, a B1, B2 visa, which is a tourist visa, and, prior unauthorized work, things like that. So that's what they want to do. Whether they can do this or not is the next question. So the policy announcement itself cites a whole slew of case law, which is purported to support the administration's position that adjustment of status is discretionary, it's a special form of relief. But the case law that they cite does not say what they say it says. It's a huge stretch by any measure. Most of the cases have nothing to do with saying that adjustment itself is an extraordinary form. Most of them are related to removal cases, related to criminal kind of removal proceedings and things like that, without getting too much into details. So that's one problem. Another problem is that this policy announcement also directly conflicts with the law itself. Adjustment of status is not only allowed, but there are many regulations and the law itself regulations implementing the law and the law itself that allow for adjustment of status for a lot of people that the administration wants to exclude. So, for example, for EB-5 applicants, there was, the RIA was a law that was passed in 2022 that explicitly not only allows for adjustment of status, but says that USCIS shall consider these applications as properly filed. And then there are other provisions like INA 245K, which allows for certain employer-based adjustment applications, as well as EB-5 applicants, an extra 180 days to file after their certain status lapses or if they have unauthorized work. E2 visa applicants, for example, have a path to adjustment of status, or it's contemplated at least, because there are special forms and relating to E2 adjustment. And there are special provisions relating to it. So all over the place, there are conflicts with this policy. And pretty much everyone expects that this will be challenged, right, in court. So the problem is, what do we do in the meantime? So it takes time for litigation to happen. It may also take time for, attorneys to figure out the best litigation strategy, most likely a violation of the Administrative Procedures Act or some other legal means to bring this in front of a judge and say, hey, they can't do this. This is incorrect. It's unlawful. So we're going to see what actually ends up happening. From my reading, since they made the initial announcement, they've already started walking back the policy a little bit in other statements that they've issued since then, which is pretty usual for this administration. They start big and bold to get people's attention, and there's a lot of PR, involved in that. And then they start walking it back as perhaps they realize that this is not legally sound. So we'll see what happens. But for the time being, it applies to all adjustments, including those pending. And the only categories that are explicitly excluded are where there's a specific statute related to adjustment, and it has to do with very peculiar avenues for adjustment, like specific legal acts, like I believe there's a Liberian Adjustment Act. There are a few others that are very specific. So, nothing other than those specific categories are explicitly excluded. You can expect that it will generally apply at this time to most adjustment cases, including those that are pending.
Okay, thank you, Nusrat, for explaining us in detail about the policy. So I have a few questions that I feel like every other person over here might have the same question. So I'll help them out with this. So do you think the USCIS officer are going to exercise greater discretionary power during the interviews?
Well, that's what this policy wants them to do, and that's what they are directed to do. It's already part of the policy manual. So the USCIS policy manual has been adjusted, and the policy manual is also what the adjudicators use to kind of guide them. It's kind of their code of conduct in a way. So this is what they use. Anyone can access it online, so you can see what it looks like. But it's been, reformed and revised to list out all those discretionary factors that I mentioned and say what's a positive, what's a negative, who does it apply to. So let's take a look. I'll just go to the policy manual right now so I can show you, or I can kind of read to you what it is. So, there are all these eligible categories, who's not eligible, and, it lists out the specific categories that are excluded, which is very few, specific types. But, like I said, it's going to be a balancing factor as far as they're concerned. They're going to look at status while filing, lapses in status, unauthorized work, criminal record, et cetera, et cetera.
Got it. Okay.
For now, I will add that from attorney feedback in the field, we're not seeing anything change at this time. But sometimes this administration makes these announcements in real time and they don't even kind of train up officers. So we have yet to see what will happen.
And can this policy shifts going to impact or affect applicants who's currently has filed I-485 applications are already pending, or do they have to apply new applications or new filings, or it's going to impact the ones which are yeah, I mean, it basically, will it be retrospectively impacting or in the coming future?
Well, it's impacting the adjudication, right? So currently pending applications are subject to it. The adjudication happens at the end before an application is approved. So pending applications are subject to this policy.
Okay. All right. And how might this policy changes the impact of the advanced payroll and international travel for individuals waiting for the green card approvals?
Yeah, so again, we don't know a lot. Anytime someone travels on advanced parole and begins using their adjustment-based, it means they're pulling themselves out of whatever status they were in before, assuming they had some other status. So it's something you have to discuss on an individual basis with your attorney. Generally speaking, it's all the more important these days to continue to maintain your underlying status. It gives you an added layer of protection in case an adjustment is denied so that you're not out of luck and you don't have to just leave the country. So if you're traveling on advanced parole or you're using your EAD based on your pending adjustment, then you're kind of putting yourself at the mercy of that adjustment application being approved. Because if it's denied and you've become reliant on this adjustment pending, you don't have anything else to fall back on and you have to leave the United States if you're denied. You can appeal essentially, but it puts you in a difficult situation. So definitely it's something to discuss with your attorney if you have a pending adjustment.
Okay. And what role might past visa denials, status violations, or immigration history play in this current policy that has just came out?
Yeah, those would all be part of these negative discretionary factors. And in fact, I will read those out to you. If you give me just a moment, I'm going to pull up that portion of the policy manual. Let's see. It'll take me just a moment, but things like status lapses, prior denials, less so. I mean, it depends on why a visa was denied. So you definitely want an attorney to review your immigration history as completely as possible. You should disclose everything to your attorney and let them kind of analyze your background. So let me see. Okay, here it is. Okay, factors that may be considered. Extent to which identity can be established and aliases are disclosed. Contribute to the good order and happiness of the United States, whatever that means. Ties to family members in the United States, closeness of those underlying relationships, hardship due to an adverse decision, value and service to the community, length of lawful residence in the U.S., and any immigration status held during that residence, including the age at which the residence began, service in the armed forces, history of employment, property or business ties to the U.S., history of taxes paid, nature and underlying circumstances of any inadmissibility grounds, seriousness of violations, eligibility for waiver, likelihood that LPR status will ensue soon, respect for law and order, good character, intent to hold family responsibilities, affidavits from family, friends, responsible community members, criminal history, community service, existence of unexecuted administratively final removal, deportation, exclusion order, public safety concerns, et cetera, et cetera. Quite a long list, and it says that it's non-exhaustive. And then there are country-specific facts as well. Has to do with the specific countries that are, limited from getting visas, like the visa ban countries, and it explains how these factors will be weighed.
Okay. Thank you, Nusrat. We have like a question from Salma, and Salma is asking, hello, what about the adjustment of status for people who have visas that are dual intent like H-1B?
Yeah, so it specifically says that, visa status at the time you apply is important. And what it's getting at is, so H-1B is dual intent, meaning you are allowed to have an intent to immigrate to the United States. Some visas are not dual intent, like a tourist visa. There are some that are kind of in between, like an O1 visa. It's considered quasi-dual intent. So technically it's not dual intent, but there are some provisions in the law that recognize that you don't necessarily have to maintain a residence abroad in your home country. So this is a reason maintaining underlying status is important too. I believe that one of the aims of this policy is to keep people who enter on tourist visas to stay in the US and get married, or F1 visas and stay in the US and get married, and then apply for adjustment of status. Or people that came in on a visa and then their status expired for 10 years and then they get married to a US citizen and then they can apply for adjustment of status. Now, the law explicitly allows it, and the law explicitly allows those periods of time out of status to be forgiven. But, there are also some specific kind of caveats to those categories applying for adjustment. But that seems like one of the intentions of this policy is to prevent that from happening, and that's why they mentioned this dual intent. So L1s and H1Bs are two of the specific categories that are explicitly dual intent, and they ostensibly can file for adjustment of status. There are other categories as well. Like I mentioned, EB5 is one of the categories where the law shows that there should be an avenue for filing adjustment and that it must be recognized by USCIS. But this policy memo is so poorly written and so badly supported that it doesn't even acknowledge these contradictions within the law and how the policy is at odds with it. So it's pretty clear that this will be litigated, and it seems like it's on very shaky ground. Is
Okay.
EB1A considered? Yeah. Is that the next question, Swati, or do you have another in the queue?
No, that's the next one.
Yeah, so EB1A is not a visa, a non-immigrant visa. EB1A is an immigrant classification. So the way that works is that you're probably going to be an H-1B when you apply for your green card. So anytime you have a green card, you have to have a petition supporting the green card. That petition can be based on a family relationship or some special provision of law, or it can be based on employment, either employment-based like an employer sponsors you, or your self-sponsor like EB-1A, or you have something like a perm, or it's employment creation, which is EB-5. So that's just your petition. You need to apply for a green card with the petition, and that's what this is about. The green card application is the adjustment of status.
Okay. Is there any other questions you guys have or any concerns? Please unmute yourself and can ask or drop the questions in the chat box.
Hey, I have a quick question. Thank you so much, guys, for jumping on this call. So does the intent of this administration is to curb on the misuse, like really misuse that people do, like coming on maybe tourist visa or student visa and just they file adjustment of status? Is it to control that, or is it for everything? Like, are they going to have any specific mercy on like maybe people who have like they are professionals or they have a high paying job? Are they less strict on those kind of applicants?
Yeah, so to start with, for one thing, that's not necessarily misuse or abuse. It is explicitly allowed to file adjustment of status under certain circumstances. For example, if you marry if you marry a US citizen, you come under a category called immediate relative. And immediate relatives are permitted to apply for adjustment of status. They're not subject to a visa bulletin, and they get all kinds of benefits. Of course, the marriage has to be real and not fraudulent, obviously. And also, there's some other indications where, if someone misrepresented themselves and came in on a tourist visa, but fully intended at the time they came in to file for adjustment, well, then that's misrepresentation. And there's already a law and provision against it and it's a pretty clear framework on how that's evaluated. So if a person, for example, comes in and then within 2 weeks marries someone and files an adjustment of status, that's going to look like misrepresentation. And there are already laws to deal with that and policies and procedures related to rooting that out. So we don't want to say that it's abuse, because that's not abuse, it's permitted. But that said, I'll go to the second part of the question, which is there some benefit to having high income or being fully employed? Yes, those are all positive factors in this new framework, discretionary framework that they've laid out.
Got it. So one follow-up question. So I think I saw somewhere that visas which are dual intent, and you also mentioned like H1 or L1 at the time of filing the change of status application, that factor is to be considered. But what if someone was or entered in the US on L1A visa or L1 visa, and then they applied for change of status, like let's say they changed to F1 student visa status, and then from F1 they are filing for I-485. So what happens that? So at the time of filing the change of status application, their status is considered, or is it the one that through which they initially entered in the US that is considered?
It should be the status they're in at the time they apply. So how one enters doesn't matter so much, because that has nothing to do with your intent at the time you apply for adjustment. What matters about your intent when you apply for adjustment is what status you're in at that time. So if you're in F1 status, you just changed to F1 status, then you suddenly file an adjustment, perhaps we can surmise, according to this announcement, that would probably be a negative factor. Again, there's a lot we don't know, but it seems that would potentially be a negative factor. Okay, I think we can answer a few of these questions. Yeah, no problem. Thanks for the question. So let's look at some of these questions in the feed. What do you think? So I can answer some of these. Does a person approved for NIW or EB-1A qualify for an exception? There are no exceptions except those specific ones that I mentioned earlier that are very rare. So let me explain. Let's see which ones those are. I don't have it in front of me, but they're very specific ones that are not, they're not EB-1A or anything like that. It has to do specifically with these unusual cases. So give me just a moment. Yeah, so it's which is a Nicaraguan and Central American Relief Act, refugee adjustments of certain kinds, HRIFA, LIF. They're very specific adjustment programs, which most people, it's a small subset of people that are applying under those. Everything else is ostensibly subject to this policy. So if people are announcing blanket exceptions, that's not correct. We don't know yet what it's going to be, but according to the policy as it's been published, there are no exceptions except for those specific cases. So what recommendation will we give someone who's planning to file 485 based on approved EB1 or NAW person is on an F1 visa? This is something you have to talk to an attorney about, depending on your situation. It's a case-by-case basis. And again, do keep in mind that this was just announced days ago. It's on very shaky legal ground. When this administration announces changes like this that don't follow the law and don't follow the normal procedures for publishing these things, it's a lot of guesswork involved in how this is going to play out, because you can't predict how it should play out because it's not in accordance with the law. And what we lawyers do is we know the law and we predict results based on the law. So it becomes a lot of guesswork. So keep that in mind. Let's see.
So the next question is for Indians with green card, I-140 filed under EB2 or EB3, I-485 adjustment of status. Status doesn't get filed until the priority date is current, right?
Yeah, so the priority date has to be current according to whatever chart USCIS is accepting for that particular month. So it has to be current either according to the final action date, which is true this month, or current according to the date for filing date. So yes, you don't file until that is advanced. Your priority date is current.
Does the new memo have any impact on F1 OPT, STEM OPT holders who are transitioning to H1B?
No, it's only having to do with adjustment of status, not to change of status. The language is confusing, but those are two different things. So a change of status has to do with non-immigrant status, going from one to the other. Adjustment of status is green card. So this only has to do with the green card.
Right. What if my priority date is current for my GC, but my wife is on H1B? Does she have to leave the country for adjustment of status?
So I can't give personal advice or answer personal legal questions. This is something to be discussed with an attorney.
How does an EB1A approval affect filing form I-485?
So it doesn't. So this is kind of a strategic question. So you can file an EB1A petition with a green card application. What that's called concurrent filing. That means you're filing two applications to be decided at the same time. The green card is dependent on the petition to be approved. Or you can wait till your EB1, let's say, is approved and then file for your green card once the visa bulletin is current. Either way, the visa bulletin has to be current. So this policy isn't related to that scenario. This policy only has to do with how an adjustment of status is decided. Whether or not an EB1A is approved is not necessarily connected to it. Are there elements that cross over? Perhaps, like if you're approved for an EB1A, then you generally have to prove that you're going to benefit the United States prospectively. And you have to demonstrate that you're really at the top of your field, right? So perhaps that's considered as a positive benefit to the United States, and you can emphasize that in your green card filing. But otherwise, these are two separate things, and one is not necessarily related to the other.
If we apply for the I-485 under F1 but have approved I-797 for switching to H1B already, does this new rule apply?
This rule applies to all adjustments. So it's a pretty clear answer at this point. As far as the administration is concerned, they want to apply it to all adjustments. So whether or not it would be a positive thing to switch from F1 to H1B, again, talk with your attorney. But generally speaking, they look at the status you were in at the time. According to how it's framed, they look at your status at the time you filed the adjustment. And if you had a dual intent visa, like an H1B, at the time you filed the adjustment, then that means that it's not necessarily conflicting. So if you're an F1 and you file adjustment, that might be conflicting. If you're an H1B, that's not conflicting. Is it a positive factor if you change from F1 to H1B, assuming you're able to do that? Probably. But, again, we don't know, and it applies to all AOS.
I believe the next question is also similar in nature. F1, then H1B, then about to file EB1A, I-140. Does the current memo any impact adjustment of status? Does it affect here as well?
Yeah, just all adjustments. So if you have an adjustment of status application that you're planning to file or that is pending, that means it hasn't been adjudicated yet. So according to how this policy is framed and how it's presented, they want it to apply to all these cases. Again, this was just announced a few days ago. It's based on bad legal reasoning, as far as I'm concerned, and many attorneys agree on this. It will be challenged. We'll see what ends up sticking, what part of this ends up sticking. But as it's been announced, it's supposed to apply to all adjustments.
Raj, I believe this question is of yours and you have raised the hand, so you please.
Thank you. Thank you both of you for the great session. I would like to add another point. So basically, during the EB1A I-140, it doesn't have to do anything with this current memo, correct? Or this will only affect when you want to file AOS once your I-140 is approved. Am I correct?
That's right. Yeah, although there is a question on the I-140 that asks you what you plan to do. Do you plan to file an adjustment of status, or do you plan to consular process if you're approved? So there may be something to consider strategy-wise in how that question is answered. Some attorneys like to always answer that question with consular processing. I tend to prefer that myself. The reason being is that it gives a person flexibility. So like if you list on your I-140 that you intend to consular process your visa, then you can always file for adjustment of status later without having to file anything else. You can just file for the green card. But if you mark that you're going to file an adjustment of status on that application, then you're stuck with adjustment of status unless you file an additional form and you have additional waiting time and additional expense. And now it brings a new flavor to that question, because now perhaps they will look at what was your status when you filed the I-140 and you mark that question, consular processing or adjustment of status. So it's something we'll have to consider on a case-by-case basis and decide how we're going to answer that question. This shows you why it's really important to work with a good attorney and to consult with your attorney on these matters, because it's literally just one little question on the I-140 that many people will overlook. But these little questions can have big meaning.
Thank you. Thank you so much.
Parizat is asking if a person that has been approved for EB1A or NIW more likely to get an exception for AOS based on their contributions to the US. Does having US assets and US citizen family members help in getting the exception? What kind of community contributions are viewed favorably?
So the first part, I think we've already discussed. It seems that, yes, that might have a positive impact. We don't know. It should, based on how the policy is written. Does having US assets, and those are listed as positive factors. What kind of community contributions are viewed favorably? Well, traditionally, in other types of applications where there is truly a discretionary element, like a waiver application, you would see certain community contributions as positive, like mentoring young people, being active at your religious institution, providing services to needy people, things like that. Those kinds of things are considered positively. Anything that contributes to the well-being of one's community or the United States, those are considered positive. As far as U.S. citizen family members, the way it's worded in this policy manual change is they look at what family members you have in the United States, what's the depth of that connection, like how close are these family members, what's their status. So those are supposed to be considered positive factors as well.
Okay. Is it also possible to file I-485 even after the filing the I-140? This has not been approved yet.
Yes, it is possible if the priority date is current.
Okay. Is there anything else? Is this going to impact EAD and AP approval timelines as well?
I don't believe so. There's no indication that it will, as far as I can see. It has to do with the actual adjustment approval. So, if it's expanded, perhaps it would be, but if that were to happen, everything would slow to an absolute crawl, because it would take so much time for an adjudicator to evaluate that at every step.
Exactly. Are there any domains got exception? Example, healthcare, pharma, something similar?
No, it's not like the visa ban where there were certain classes that were excluded. So far, no exceptions other than those specific acts that I mentioned. NACARA, HRIFA, LRIF adjustments, those are supposed to be excluded from this policy. I actually now don't see that in the policy memo, so I don't know if that's been removed, but like I said, it's a fast-moving situation and it's brand new policy. So we'll see what happens. The thing about, Just one more point, just like on these domains, like if you can show a connection to the national interest and well-being of a community and your positive contributions, then yes, but there are no like blanket exceptions.
If we apply for the I-485 under F1 but have approved I-797 for switching to H-1B already, does this new rule apply?
Yeah, I think I answered that one already. So applies to any adjustment.
Yeah, I think we all done with the questions and we have one raised hand. Zan, could you please unmute yourself?
Yeah. So this is a follow-up question to Raj's question. You mentioned that there is a question on I-140 and that would impact the I-140 stage. But what if someone is on perm stage? How would it affect their perm application in any way?
Well, the perm is filed by the employer, not by the employee. So the employee, I mean, you do sign a portion of the perm application, but I don't believe, I can't recall if there are any specific questions in the application itself that would relate to this aspect of the 485, except for when it comes to the I-140. So once the perm is approved, then you file the I-140 and then that question arises. So, I think we'll take a deeper look at this, but I don't believe that there's anything within the perm application itself that will relate to this issue.
Got it. Got it. And one more follow-up question to your comment regarding showing positive equities or positive contributions in the society, in the well-being. So how exactly an applicant is going to show that they are involved in these kind of activities or things?
So what's mentioned is letters or affidavits from community members. You can also show awards, from community groups, things like that, or news coverage. The same way you would document any other fact with any immigration proceeding, you should have some evidence. But most often an affidavit is typically what's provided for these kinds of issues.
So those would need to be submitted with the I-485 application?
We don't know yet. So
Okay.
potentially, but I think it depends on what approach the attorney wants to take too, because it's like, do we comply with bad policy that is unlawful? Do we give into it and pretend that it's, okay? Or do we want to preserve the legal argument that this is unlawful? How do we deal with this issue? Or do you just wait for an RFE? Because it seems that, perhaps USCIS will issue an RFE in these situations and ask for more positive factors, or attorneys can start just beefing up applications and adding all of this information. Last time was when Trump was in office, he did add a whole extra process to the adjustment of status application and an additional form, and it required extensive financial information. That was a little bit different because it related to public charge. This is like one of the new versions of it this time around. So we'll see how it plays out and, what we decide to do. But there will be swift litigation, I'm sure, once we decide, various attorneys decide how exactly they want to approach the litigation.
Makes sense. Thank you so much.
One more question, and it says, how does AOS policy shift affect if anyone is in the country on J1 visa?
J1s have their own peculiarities. So it depends on what country you're from and if it's on the skill set or if it's related to medical training. So there are a lot of different varieties of J1 that have to do with whether you can really apply for an adjustment anyway, or if you need an exception, a waiver of the home residency. So that is one element of it. But a good kind of way to think about it is it applies to all adjustments. J1 is a non-immigrant visa. It is not a dual intent visa. So that's something to consider.
And what is the probability this can be challenged and rolled back?
100% this will be challenged. Whether or not it will be rolled back, we'll see. I think it should be based on the law. We'll see what version of it sticks. So there's a lot that goes into analyzing these kinds of policy changes and how exactly they can be challenged. So it is still evolving and we'll see, but it will definitely be challenged. We just don't know when and what the final iteration of this policy change will look like.
I believe all the questions.
One
Okay.
quick question. Nusrat, do you want to comment on the legality, like how it's drafted? It just seems like it's just a policy memo. They are not trying to amend any law or any regulation. It's just how they interpret. So do you think its legality is, it doesn't have a proper ground to stand on? Do you think that is the
Well,
case, or?
they are trying to change the law because they're doing it in the guise of a policy memo, but this is often how these things look. So they say it's a policy change, it's not a change in the law, but it is at complete odds with the law in several areas. So therefore, they are trying to change the law, and they're changing the law or trying to change the law on a few different grounds, not just the law where it's in conflict, but also with regulations. So federal regulations for administrative agencies interpret the law and they administer the law essentially. But in order to publish these regulations or any changes in regulations, you have to go through a certain particular set of procedures. That is according to the Administrative Procedures Act. There's supposed to be a published rule. There's supposed to be a notice and comment period. That's assuming the rule is in compliance with the law. So that's another level there. So one of the challenges that can be posed to this is that this is an unlawful violation of the Administrative Procedures Act, the APA. This administration is trying to change regulations without going through the proper procedures. Or the other way is this is in direct conflict with the law. This is not what the law says. This is not the intent of the law. You look at the congressional notes at the time the law was passed. You look at the way the law has been applied over the many years. You look at the case law, which I mentioned does not necessarily apply. The case law that they cite doesn't make sense for them to use in this way for the most part. So, they are actually trying to change the law. So this is something that we're just, there will be litigation challenging it, and there are a few different ways you can challenge it without getting too nerdy about legal stuff. But once, maybe there'll be several types of challenges to it. But once that litigation happens, we'll see what the end result is.
Okay, I believe we just finished all the questions. Thank you so much, Nusrat. It was from May 21st to now. A lot of questions were there in the mind. What's going to happen, how it's going to happen, which visa is going to impact. And this session has made us a little bit clear about how we should perceive this policy. And we should we should wait and understand how it's evolving to make sure that people who are planning to file I-485, they should plan it accordingly and also stay tuned with what are the repercussions can happen. So thank you so much for coming and sharing all the insights and the meaning of the policy. And thank you everybody for joining us and asking wonderful questions. See you once again.
Thank you all so much. All right. Thank you. Take care.